Hello everyone and welcome to this short video. This is Jones Chase's A to Z of employment law, and today I'm dealing with the letter I, which is about international mobility. There are some really important points in this video for you to be aware of if you have any employees working and living outside the UK. So what is international mobility? This is becoming a key topic in employment law since the coronavirus pandemic, with employees being handed the freedom to work from home, with home not being properly defined. It can lead to employees working overseas, and the important question is, what does this mean for employers? Firstly, employees will typically get the benefit of the domestic law of the country they are based. This is a complex area, but in short, the principle generally means that if your company is based in the UK and has hired individuals who live and work in a different country, their employment rights will most likely be governed by the law of the country that they live and work in, even if they are hired under a contract which is stated to be governed by UK law. Careful attention must therefore be paid to the law of the countries where your employees are based. Countries such as France and Germany have a number of pro-employee provisions, which will give any individual bringing a claim who works and resides in these countries strong, and in some cases, enhanced protection that UK-based employers ought to know about. Conversely, countries such as Qatar offer less employment protection for employees. Thus, should the individual work and reside in Qatar, this is the law that will likely apply. It is also notable that US employers operate the concept of employment at will, which is very different to the UK's law of unfair dismissal, for example. We always recommend that legal advice is taken from a lawyer qualified in the local jurisdiction, and as Jones Chase is part of a large international network, we would be happy to provide you with a referral if needed. So now looking at other circumstances where people can still get UK employment rights, the courts have stated that the rule that I just mentioned is only a general rule and that exceptional factors can lead to an alternative outcome. This means that despite people living and working overseas, they may still benefit from UK employment rights in certain situations. The leading case of Lawson and Serco from 2006 does indeed show this. This case identified that where the employee works and is based abroad, but they were recruited in Britain by a British employer, this does not necessarily mean the employee will be covered under the Employment Rights Act of 1996. Something more will be required. Examples of this can include working for a British employer operating within what amounts, for practical purposes, to an extraterritorial political or social enclave in a foreign country, or being posted abroad by a British employer for the purposes of a business carried on in Great Britain, such as a foreign correspondent on the staff of a British newspaper. The employee will need to establish a sufficiently strong causal connection with their employment relationship to the UK employer, and if this can be done, UK employment law thus would apply. Employers will need to be aware of this in circumstances where the employee is provided with less favourable employment rights in line with the country in which they are based in, such as a lower minimum wage or amount of holidays, and this can lead to an employee successfully bringing a claim against their employer. Employers should also be aware that employees may have the option of forum shopping. This is where the law of more than one country can deal with the proceedings, and one country is either more advantageous or disadvantageous to one of the parties. Employees would typically pick the most favourable law for them, and we can help to advise companies of what to do in this situation, should it occur, in conjunction with a lawyer in the competing jurisdiction. Now looking at the impact of international secondments and how that works. So a secondment is the temporary assignment of an employee from one organisation to another or another group company for a specified period of time, usually to carry out a particular project. It can be an intra-company transfer within the same organisation or between two unrelated business entities. It can also be an overseas assignment. During the secondment, the employee usually continues to be employed by their original employer, and ordinarily the original contract of employment subsists, though it is supplemented with a secondment agreement. At the end of the secondment, it is anticipated that the employee will return to their original position in their home country. The issue with international secondments is that the secondee may be able to bring claims arising from their employment against the employer under the laws of their home jurisdiction, but also if the secondee acquires employment rights under the local laws in the host country. Ideally, the secondment agreement should take into account the law of the host country, and this is something that we frequently recommend to our clients from Jones Chase. Please also make sure that you have taken care of all the necessary immigration requirements. I briefly wanted to mention tax considerations. Furthermore, the tax treatment of an overseas employee will need to be carefully considered. We are not tax advisors, but do be aware of the risk that employees, and therefore the company, may need to pay tax in the country in which the employee is based. This applies to employees who are permanently based overseas and also to lengthy international secondments. The costs of getting this wrong could be significant. Finally, looking at the difference between employees and consultants, there is a difference between the treatment of overseas employees and consultants or contractors. In short, UK-based hiring companies tend to have more flexibility and options when dealing with consultants and contractors compared to employees, as consultants tend to have fewer employment rights and may not be caught by the full range of local legal protection from the home country. Again, this is a complicated area, and as this is only a 5-minute video, I have not had time to speak about the issues of the choice of law of the contract, i.e. whether UK or otherwise, or which country claims are enforced in. If you have any questions or you would like to discuss the areas I've talked about, please do contact the Jones Chase team on 0203 837 9914 or visit joneschase.com. We would love to help you, and I hope that you have enjoyed this video.